So feel free after the address to to ask your questions. So introducing today's speaker. Justice Marvic M.V.F. Leonen is currently an Associate Justice of the Supreme Court of the Philippines. He's the former Dean and a Professor of Law at the University of the Philippines College of Law, wherein he started in 1989. He graduated with an AB Economics degree, magna cum laude, from the UP School of Economics in 1983, and obtained his Bachelor's of Laws degree from the College of Law in 1987. Later that year, he co-founded the Legal Rights and Natural Resources Center, a legal and policy research and advocacy institution, focusing on providing legal services for upland rural poor and indigenous peoples communities. He served as the center's executive director for 15 years. He also earned his Master's of Law degree from the Columbia Law School of the Columbia University in New York. He first joined the faculty in 1989 as a professorial lecturer in Philippine Indigenous Law. He became assistant professor during Dean Agabin's term and academic administrator during Dean Magallanes' term. In 2000, he was invited to act as the UP System's University General Counsel. In 2005, he became the first Vice President for Legal Affairs of the UP System, and in 2008 became the Dean of the College of Law of the University of the Philippines. In July 2010, he was named by President Aquino as the Philippine government's chief negotiator with the MILF, More Islamic Liberation Front. He successfully led the parties to a framework agreement on the Bangsamoro, which was signed on October 15, 2012. In 2012, November 21, 2012, he was appointed to Supreme Court. Ladies and gentlemen, Supreme Court Associate Justice Marvic Leonen.
Thank you for that generous introduction. And I will dispense with the salutations, but I would just want to recognize several of my colleagues who are here. I think Professor Gwen Greta is here, your professor, checking attendance. Also Professor Charlie Yu, a very good friend of mine, is also here with us today. And in the spirit of the UP tradition, I thought that it is best that I conduct this as if it were a class, without recitations. But first, just to get to know the audience, may I know who here are not law students? Are not law students? One, okay, two, yes. Who here are students of the best law school in this country? At Ateneo kayo. But well, it is such a delight and a restful day for me today because I come back to the College of Law, where I spent quite a number of years in this platform teaching law students, many of which have went on to become judges. Some are in my chamber now, acting as my confidential attorneys and law clerks. And to talk to you this morning without presence of media, hopefully. And in case you want to tweet anything, please be careful. I do not want to be impeached at a very early part of my career in the judiciary. First, maybe let me just emphasize to you that what you are entering is a profession that is a service profession. It's a profession that is not about you. It is a profession that is about people that will depend on you. It is a profession where you will have to lose your personality, follow the rules that are in our canons of professional responsibility, and if you become a judge, the canons of our judicial ethics, and lose yourself in favor of the interest of your client. When you take on your client, you take on his or her personality, whether that is a person in itself, a natural person, or a corporate entity, or whether it is government that you are representing. If you come here and if you are in your first year of law school, dreaming about your ambitions as a person, perhaps the first thing to do is to check your ambitions and again understand that you are not here for yourself, you are here for other people. People go to lawyers not as a luxury. People go to lawyers when they are at the end of the room, when they are desperate, when they actually need assistance against the behemoth, which Hobbes referred to as the Leviathan, which is now called the state or the government, the government. Or they go to a lawyer because they arrange against, let us say, a very large transnational mining corporation, the MRT, for people that have been derailed or injured because of the derailment of a caboose of one of the MRTs. And of course, they are depending on that lawyer to protect their interests. That's why, as a profession, and as a service profession at that, you're required to be able to do things in favor of a client. That decision point for you to lose that identity every time you have a client is when you accept that client or when you join an office that is in-house to a corporation or in-house to a government agency or joins the judiciary, in which case you render fealty to the Constitution and all our laws and be fair with respect to all the litigants. But I have good news. Even though you are not muscular, you are not big, you are not strong, your words can carry a lot of weight. A simple document, which you will call a pleading, will give rise perhaps to a warrant of arrest that will perhaps arrest a senator of the Republic because of their involvement in plunder in relation to the pork barrel plunder. A simple pleading and some arguments, some words from you in a court of law, properly uttered, with a lot of respect and diplomacy to your opposing counsel, will be able to give you a writ which is called a temporary restraining order or a writ of injunction against perhaps the largest mining firm in this country in order to stop it from occupying lands of people that have not even reached the elementary grades and who may be called upland rural farmers or indigenous peoples. Just with your words and nothing else. Just with your knowledge and nothing else. Just because you are capable and competent enough to be able to know what the proper procedure is, and also capable and competent enough to actually read your opponent, read what it is that they do, read the entire mechanism of the judiciary, and are able to get that writ or that order or that final order with a value that can perhaps read that billions of pesos that have been used under the disbursement allocation program, some acts and practices will be unconstitutional and all the consequences will follow from that. Can you imagine that power that you have? Right now, of course, you are just plodding your way towards gaining that power. It is as if you are in training because you are reading each and every case, and in each and every case, well, this is the time that I think that you should be able to understand that you are empowering yourself as you read through cases. If you slip through the RH case, the Igbong et al. Case, especially if you slip through my dissent, then you will miss out on a lot of things that you should be able to know and therefore arm yourself against a future litigation of a similar sort. Maybe even the concept of judicial review, even the concept of judicial restraint. It may appear boring to you because these are all words. And it may be in your mind you will say that you will study it more carefully when you get to review for the bar or even after the bar when you actually practice in a particular case. But let me tell you a reality. The time for you to strengthen yourself, your knowledge, is now. When you go through the cases for the first time, when it is assigned to you in constitutional law. You are all starting from the same starting line. But he or she that is more diligent, more attentive, okay, more critical in terms of their reading, will go or will sprint far ahead of many others. If you are relying on digest at this very early stage of your career as a lawyer or as a future lawyer, then I am telling you that you are left in the starting line. If you are relying on the synopsis of the court reporter, and I know how they make that synopsis, rather than reading the entire case, savoring every sentence that we put in a decision, because every sentence that we put there certainly matters in the argument or in the deliberation that we have had, and failing to see the kind of innuendos and the kind of debates that we have had, the differences that Supreme Court justice will have, will therefore lead you to peril. Because then if you are not aware of it, you miss out on a lot of things. It is that person that sits down, understands why he or she is interested in the law, understands why he or she should be motivated to sit up, be awake, be attentive, and be critical. It is that person that will become so powerful that when they appear before the Supreme Court, their name itself will already give them an advantage before the 15 justices of the Supreme Court of the Republic of the Philippines. There are only a few that can do that. And in my mind, when Salonga appears, if he were still alive, if a Jose W. Jokno appears, it would be different because the poor lawyer appearing for the opposing party will therefore be at a very large disadvantage. Why? Because of the reputation, the skill, the knowledge, the creativity of that particular lawyer. So you stand not for yourself, but you stand for the client. Therefore, your loyalty to your client is very important. And loyalty means that for so long as you are counsel to that party, you will not put your client in peril. In the medical profession, as we have discussed in the case of the reproductive health law, there is a principle called first do no harm. In other words, whatever it is that you do as a doctor, you should never imperil your client. Whatever it is that you believe as a doctor, in my dissent I said, even your conscientious objection should not feed to the detriment of your client, of your patient. The same with your client. The only way for you to be able to be relieved of the responsibility from the orders of your agency, your principal, your client, would be for you to resign your post or to tell your client that you are disengaging from that entity. So again, I emphasize, if you still do not realize that you are not here for yourself, you are here for others. And this probably explains why the education in this College of Law is so harsh. Because until and unless you are able to meet all the adversities in a courtroom and out there, until you're able to maintain some level of equanimity in spite of the brickbats that are coming out there, then that is the only time that you can protect another person who comes to you desperate for assistance because they are in trouble with another human being, a large corporation, or perhaps the law itself. Okay? The most difficult cases challenge you also the most. And difficult, I refer to not the complexity of the issues. If you are from the UP College of Law, it should be easy for you to break it down, to be able to analyze it from various fields of law. The more difficult cases are the cases whose outcomes will have some effect on your society or on you as a person. These are the difficult cases. If you were to become a justice or a judge of our judicial system, that would mean having to decide against the interests of your family, the identities that you have been advocating for when you were a legal professional, not a jurist or a judge or a justice, or perhaps against the very power that put you in that place as a Supreme Court justice itself. I think they call this principled decision making, and I think the attitude that goes with it is called integrity. And integrity, of course, means what you do when there is no pressure on you to do otherwise, when nobody else is looking, but you think that that is what is right. Difficult cases are cases that have large political impact also on many of the people relying on the counsels that go to a court of law. Therefore, in those situations, you cannot afford to be of lack of competence. You cannot afford to be incompetent. It is your competence that gives you the intelligence to be able to break the issues down and approach it the way it should be approached, according to law, according to the Constitution, and according to conscience. So again, my first point, you are not here for yourself. You are here for another human being or other human beings that rely on your assistance. Okay, so if you are here, the difference between a lawyer and an artist is that the artist creates a painting, creates music, puts it out there, and it is attributed to him or her. A lawyer, on the other hand, you have a pleading, but the benefit will not be yours. The benefit will be that of the client who escapes from prosecution because it is acquitted. or who is able to gain a contract and is able to actually pursue the interests that they want to actually pursue. So again, you are not here for yourself, but you are going to be very powerful. You have to understand that responsibility. Now, there are 5 things that you do as a lawyer. 1 is understand the facts. 2nd is understand the law in relation to the facts. 3rd is understand the best procedure to be able to bring your cause about. And 4th would be to help maintain the system. And 5th would be maintaining the system and doing all of this to understand that what you do is for the greater good of the society, of communities, of peoples that you are representing. Again, you look at the facts, you look at the law, you decide the procedure, you maintain the system, you help maintain the system, and finally, you always have your vista, because you're from the University of the Philippines, in favor of bettering society, of making a difference in the lives of many others. Let's go through it one by one. Knowing the facts. Okay. Actually, every human being, according to Kahneman, who is a Nobel Prize award, a psychologist, I think there are some psychologists amongst you. All of us have our own heuristics and biases. In other words, because we are human beings, we try to make sense of the world outside simply because there are things in our mind that tell us to do order or to make it reasonable and to put it in order. For example, there is what they call availability heuristic, which means that people are more concerned about terrorism than, for instance, the perils of second-hand smoking. And the reason for this is because terrorism creates a lot of good media copy. So you read ISIS, you read about what they are doing in the Middle East. You read about the implications of some of our politicians that ISIS has influenced the Bangsamoro Islamic freedom fighters in Maguindanao, which is of course not true. And therefore, you are very concerned about this type of terrorism. You read about the link between terrorism and Islam. Without thinking, you say that they are terrorists because they are believers in Islam, because they are Muslim. And therefore, you are on your way to an irresponsible conclusion, which is that everybody who is Muslim is a terrorist or has the potential of being a terrorist. On the other hand, being Catholic is preserved because nothing in the media implies that people, for instance, the people that take a gun and enter a school in the United States and start shooting everyone at random are Christians. It is not in the media. Therefore, what is available to you is what you read in the media. And therefore, it is what you are concerned about. And therefore, when it is triggered by a face of a Muslim, by ISIS, by what happens in Mindanao, you immediately conclude that it is something more important than anything else. However, when you look at the statistics, there are more people that die because of second-hand smoke. There are more people that die because of hunger. Hunger, of course, is sometimes invisible because you do not feel it, you do not see it, and it is not part of the news because there is no drama in it. I mean, it's more dramatic to look at the 2.8 billion parking building. I'm just stating the facts. Rather than, of course, looking at somebody in Maguindanao who does not eat 3 meals a day and who will probably have difficulty finding 1 meal. Or perhaps just go out into Pilcoa, walk around, and see the people that do not have shelter, that have to sleep on the streets, and ask them what they have eaten and when was the last time that they had a good meal. Okay? These people are invisible. Therefore, in view of this, the legal profession teaches you how to deal with facts. But unfortunately, in some instances, lawyers succumb to their natural state, which is that they try to understand facts from what they see. Another example, the precautionary principle of environmentalism. The precautionary principle has 3 variations. But of course, the general variation is, in the absence of clear scientific finding, it is better to do the remedial measure than wait until there is clear scientific evidence. Cass Sunstein, an academic from the University of Chicago, who is now advisor to President Obama with respect to regulation, say that sometimes what the status quo is not denied. Sometimes you do not do anything, and if you do not do anything, it is worse than being able to do anything. In other words, therefore, some of these principles need to be rethought and examined very carefully. The legal profession tells you to be objective, and there is a particular way by which you are going to accept facts, and this is through the rules of evidence. Await until there are residual facts that prove the existence of a particular fact, and from there, you make your judgment as to whether those facts exist. In terms of lawyers, your skill would be to marshal all of these facts from a client that does not have all the resources. A poor person is accused of having staff let us call him Barbie in a parlor. Okay? This poor person happens to be gay, happens to be the best friend of Barbie. Barbie, by the way, is a man. He is stabbed 22 times. By the way, this is an actual case. And it is one of the cases where we were fortunate enough to be the ponensya. Stabbed 22 times. After having been stabbed 22 times, of course, he died. There was a witness that saw this other gay person come out of the parlor, and this witness testifies that he saw the face, and he saw that he left something on the ground and was unable to take it. The following day, the police came. They saw that Barbie was clutching several strands of hair. Yes, it happens in the Philippines too, etong forensics. Okay? They found strands of hair. They went out. They saw the knife. There were fingerprints on the knife, but unfortunately our police did not have gloves. So they handled the knife with their bare hands, and unfortunately these both evidence were not presented in a court of law. The person who was seen going out of the parlor was convicted on the basis of eyewitness testimony. Just one eyewitness that swears that it saw this person come out. The question is, what happened to the object evidence? What happened to the forensic evidence? A lawyer failed to do its job. And that lawyer is the prosecution. Because then it's the prosecution's role, your role as lawyers, to bring everything possible in order to establish your case, including the evidence. And more often than not, you will only rely on evidence that is available or evidence that supports your case. A good lawyer should look at the argument of the other side and try to protect it. Nonetheless, they did not present this evidence. This person who was accused has been incarcerated for as long as more than 8 years already, only to be acquitted later. But 8 years staying in prison, can you imagine that? Just because a single lawyer did not present the evidence, or his defense counsel did not argue enough. For if you lose a case, there is no one else to blame primarily except you yourself, because you did not do everything legal and ethical in order to be able to get your client off. In any case, therefore, that is one of the important things. Next, questions of law. Can you imagine if you became the advisor of a president of the Republic of the Philippines? The president, whether or not he or she is a lawyer, acts like a politician. What he does is, of course, do what he thinks is good and best for the country. However, of course, as a lawyer, you will tell the president, this is how to do it. This is how to move billions of pesos from one appropriation item to the other appropriation item. This is what the Constitution provides. This is what the Administrative Code provides. Reading the law. Okay. If you make a mistake, and later on you will find out that a Supreme Court of a particular historical period would say that what you did was in contravention of either law or the Constitution, then somebody will have to suffer for that. It will bring an entire moral crusade of a president into it will slow it down, if not actually halt it. Why? Simply because legal advice was not properly given. And why was legal advice not properly given? Because during constitutional law or administrative law, that person was sleeping. Or that person was studying how to get the digest of the classmate in the other room or whatever. But the point there again, the importance of competence in understanding the law. There are lots of laws. There is the Constitution and thousands upon thousands of statutes. And the question is, do you need to be familiar with all of them? And my usual answer is yes. You need to be familiar with all of them. At least have a working familiarity of all the laws in general, or the kinds of laws in general. And when you specialize, you need to be so thoroughly familiar with them that you can recite them in your sleep. We had a debate here once with some faculty members over lunch as to whether we should ask the student to memorize or not. My position is, you memorize the Constitution. If you were in my constitutional law class, my position was in the rules of court. When you are in my procedure class, you memorize the rules of court. Not only the rules of court, Sun Tzu's The Art of War. Wala lang, extra lang. Okay? And you read Ophel's Fundamental Legal Concepts. And of course, Twinning and Myers, How to Do Things with Rules. That's a gem of a book, which is very old and it's very in the research section, which very few students do. How can you manipulate rules? How to do things with rules. Medyo maganda yung title niya. Twinning and Myers should have said, How to Manipulate the Law. Okay, which is very good. And then, of course, top it off with Holmes' concept of the bad person. Well, he called them at that time the bad man. But Holmes was not gender sensitive, so we call him now the bad person, the path of the law. Okay, in any case. Why? Because familiarity with the law will have it in your fingertips every time there is an issue before you, and you have that advantage over another law. Just yesterday, I had the fortune of being able to consult with an expert on the law of the sea. Okay, because of a pending case, we are allowed to do consultation so long as that party, that lawyer, is not a party to the case, especially with academics. And over the phone, without any warning, he was able to cite to me, chapter and verse, the provision that I might want to see. And I tested it. I looked at the unclos, and lo and behold, very precise. It was there. Okay? Phone call. Okay? Kaya in your sleep. So when your client, when your mother or father wakes you up, anak ko, ano ba yung provision sa murder? Nakapatay yata ako. You should be able to repeat it. Ano ba yung penalty? With indeterminate penalty, you should be able to compute, including exemplary, moral, or temporary damages. Kasama dapat yan. 75, 75, 50 normally, or in the case of Gambao, 100, 150, or you can go up to 200, 250 if it were incest, or and so on and so forth. People versus Gambao. Anong legal interest rate? The car frames. Very recent case, 12% until July 31 of 2013, and then 6% after that. Ganun dapat. Why? Again, because you have to be familiar with that particular law. Your state of facts, your understanding of the state of facts depends upon your understanding of the law. That means that you will search for the facts that are only required by the law. And therefore, it is important that you are thoroughly familiar with the law. Okay. Now, laws, on the other hand, are validated by a more fundamental law, and that is called the Constitution of the Republic of the Philippines. And let me state this very clearly. The Constitution is what it is. It is what it is not in 1986. The Constitution is what it is now. It has text, it has language, it has phrases, it has entire sentences, and the words that we read now are the same words that were read in 1986 when it was created. However, words do have a settled meaning within a particular frame. Settled meaning within a particular frame. So when they say Congress in Article 17, which is on amendment, then it means Congress with a capital C. That means both the Senate and the House of Representatives. Okay? When it says that the Judicial and Bar Council shall determine the probity, the integrity, the competence, and the independence, then it is the Judicial and Bar Council, and not the Supreme Court that will determine the integrity of a candidate. And that means, therefore, that our duty in terms of your courts and your duty as lawyers is to invoke the jurisdiction of courts only insofar as to declare its competence in relation to certain things. Words have settled meaning within a context. However, in certain instances, words are often also open textual. I do not know if you have read Chavez versus Judicial and Bar Council. Chavez versus Judicial and Bar Council. Your Supreme Court last summer, no, the summer before that, was confronted with a very interesting issue. The provision on the Judicial and Bar Council's composition said that Congress shall be represented by a representative of Congress. A representative of Congress. That was the phrase. Now the problem was, Congress was in capital letters, and Congress meant Senate and House. It was bifurcated. And a representative, of course, in ordinary English, means one representative. However, when you allow one representative to represent Congress at any time in the Judicial and Bar Council, which one should represent it? And they said, it is only one who will represent the House and the Senate. And so my question was, Senator ba o Congressman? Which is more important? When a senator sits, the senator represents the Senate, not the House of Representatives. It will get instructions from its committee within the Senate. If a congressman sat, that person will get instructions from the House. So therefore, a representative, you would either emphasize on the a or on the representative. Text one. Okay? And guess what? Of course, I lost because my emphasis was on representative. Because I said between a and representative, representative is more in accordance with the purpose of the Constitution, which is to get the ideas of all the sectors in terms of vetting a candidate. Now, A, on the other hand, has no meaning without something that it describes. It is an article as a part of speech. Therefore, when you focus on the A, then it might lead to an absurd conclusion that you will have one half of a senator and one half of a congressman representing the Congress. Ikalahating vote daw, pwede. And therefore I said, which of the senators will admit that they are half of the legislature? Okay? Yung mga nakakulong, yung mga hindi nakakulong, I don't know. What about a congressman? And therefore, the point was, it is impossible to have one. What do they do now? They alternate. And when they alternate, of course, the first alternate will not be representing Congress. It will be representing the House. That's something nice about being able to give a lecture after you lost the vote and the decision is promulgated. You can convince law students that you are right. So that when you become a justice of the Supreme Court, therefore, you can help me overturn, because I will still be there, hopefully, you can help me overturn that decision. You know, a dissent is a statement of hope. Okay, that's how I look at it. A dissent is a statement of hope that in the future, the justices of the Supreme Court will see what is right, and what is right is what is honestly. But the dissent, of course, is of course an idea that there is another approach to a particular case, except that we lost the ideas of others. Now, question: what gives the Supreme Court the authority to overrule the House, the Senate, the President? What gives us that authority if we are not elected to actually cause a result that may alter policy? So that has been a very difficult question in constitutional law. Alexander Bickel calls it the counter-majoritarian problem. Why is it that you need a Supreme Court? Why is it that we follow Marbury versus Madison in the text of the Constitution? That's why when they say you should amend the Constitution to remove judicial review, tumataas na yung kilay ng iba. Because they ask, is a judicial review inherent in the judiciary? Well, to clip the powers of the Supreme Court, it is clipped every day. With every decision that we come out where there are concurring and dissenting opinions, judicial review is shaped every time you have a political case that is forwarded to us. It was restated in the case of Cardinesa versus JIC very recently. And again, it will be restated in upcoming decisions that have to do with, let us say, freedom of expression, etc. It was restated in the case of the RH cases, the PDAM, the DAM cases, and so on and so on and so forth. It is in flux, what the concept is, or what the actual restraint should be. But then back to our question, what gives us that authority? It is a problem addressed to academics, but it is also a problem that should be addressed to the Supreme Court. Every day we should ask ourselves, do we substitute this just because we like it? Or do we do this simply because in our conscience we know that this should be the intention congealed in these particular provisions? And the check there is that you have 15 justices of the court, none of which are more dominant than the others. Forget what you read in Manila Times or any other newspaper. The reality is, every justice, when we deliberate, has to have their say. Of course, the more senior justices can say it first. Yan yung tradition namin. The most junior always says it last. There is a disadvantage there because whoever speaks first frames the issue. And if you do not have the skill, at the end of it, when you are asked, because I was number 15, you have to deal with that issue and try to reframe it so that you will win. On the other hand, you do have only one vote compared to the others. You have 15 of the justices. What holds them to account? Of course, back of our minds, we know the Constitution. There is always Article 11, Section 3. There is always the concept of impeachment. You do not need to remind us. We live with it every day. Okay? Is that an impeachable offense, the fact that you ate that kind of lunch? Okay? And so on and so forth. Is that an impeachable offense when you wrote this, in spite of the fact that you went against precedents and are now forwarding a new precedent? Is it an impeachable offense to actually say psychological incapacity should not be determined only by a psychiatrist and a psychologist? Psychological incapacity can also be determined by the religious institution to which the parties belong. Because psychological incapacity is not truly only a scientific idea, it is also a legal idea. As a matter of fact, is it impeachable to say that that provision of law is unconstitutional because it establishes a religion? I'm only asking. But it is not yet jurisprudence. Baka mali sagot nyo sa exam. But when you take the bar with me, as a bar examiner, you will be one of the brave 200 that will only take the exam with me because I will only pass about 1%. And so on and so forth. Not just kidding. The point there is that the actual doctrine now is different. Is that impeachable? We ask ourselves. Culpable violation of the Constitution, a judicial matter, perhaps not if you get the vote. Therefore, you can overturn Republic versus Molina. You can reinstate the idea of Agara versus Electoral Commission in terms of judicial restraint. You can remove the very concept of transcendental interest. You can limit the applicability of transcendental interest to only locus standi. Okay? Or for that matter, you can say that Oposa versus Pacora, insofar as you allow a child to represent your own child, generations yet unborn, is unfair and absurd. My daughter and the daughter of my daughter does not necessarily want to be represented by somebody who files a petition in court that it represents all generations, including those unborn. There's something wrong with that. And therefore, it can be the subject of a lot of abuse. On the other hand, therefore, these are what we encounter every day. Again, nobody has to remind us. We are, of course, always knowledgeable that there is an outer extent of what we can do. However, you know what is lacking? What is lacking is genuine criticism of the decisions that we come out with. And by genuine, I do not mean nag-away si Justice so and Justice so during deliberation. Let me just tell you, frankly, in that deliberation room that is only attended to by the 15 justices and no other staff, except si Mang Timoy na nagdadala ng kape. That person knows so many Supreme Court courts already. Bayaran nyo lang ng konti, magsulat siya. The real history of the Supreme Court. Si Justice Leonen kape, 1 sugar. Kapag nagde-deliberation sila at naglilibre si Chief ng Starbucks, ito yung listahan na kailangan mo. Okay? Some deliberations, you will see us with Starbucks cups. Until former Professor Tech told the Mang Timoy, huwag mo ilagay sa Starbucks. Baka sabihin nila, we are endorsing the product. So, pakilagay mo na lang sa container. Or some of the judges have said, hindi malasa ang Starbucks kung wala dun sa paper cup. Might be toxic, I don't know, but you have to find the facts for yourself. Okay? So, not that kind of fight, but the deliberations about transcendental interest is too loose, or has applied to everything, even actual case, by this particular decision. When you waive actual case, which means that there is a real controversy, which means that you are only acting on the basis of a law that was passed, without the actual facts on which it is made to apply, then therefore you are rendering an advisory opinion. Walang ganon. Justice Leonen's debate about the exemptions for doctors with the conscientious objection is very absurd. I want to hear that. Okay, of course, I will ask somebody to respond quick. Please lang pakisagot lang ito. Hindi absurd yan. It's only unreasonable. And so on and so forth. Or for that reason, the removal in the cybercrime law of that provision which says that you have the option to actually compel advertising from stopping to give you junk mail. Okay, yun ang tinanggal. That was the only thing declared unconstitutional in the cybercrime law. Not cyber sex provision, or not, what is this? Not cyber libel. Okay? Cyber sex. It says for consideration. So kung libre, I mean, there are sites in the internet. I am told that there are sites in the internet where you can download material which are titillating for free. Okay? UP Law website for titillating yung cases. But in any case, where you have YouTube and you have others. Okay? And I will not mention them because I do not know. In any case, I should say that kasi impeachable din yun. Okay, but in any case, so that should be criticized. Why is it that we are so overly protective of commercial speech, but not protective of political speech? Why is it that we allow the state to control our bodies by simply saying any lascivious graphic representation can be the basis of a criminal prosecution? Why is it that we allow, the Supreme Court has allowed, despite some dissents, why is it that it allowed that libel now, when done in the internet, is no longer probationable because it's double the penalty, simply because it is done through the internet? On the other hand, why is it that we prosecute a criminal offense called libel when civil liability is also there? There is no or very little criticism on the substance of our decision. And I can understand media, because media does not have the time or the trouble nor the patience to go read all of our cases. Can you imagine to go through 100 pages of a separate opinion? Separate lang yun. Okay? And in the RH law, 10 of us wrote very long pieces. 10 of us, very extraordinary. Usually, sasabihin mo ba ito? Hindi. Masasabihin mo, just join nyo na lang. I will just write on something else, another case. Pero dito, nobody was satisfied with each other's opinion. So all of us wrote our own opinion, all 10 of us. Kung di namin napigilan yung 5, siguro nagsulat din sila. Okay, but in any case, tas meron pang Tagalog. Okay, which is of course more difficult for us Ilocanos. And I was kidding the Chief Justice. The national language is Ilocano, and Cebuano, and Maguindanao, etc. Bakit ka Tagalog lang? And the Chief of course said, Filipino is my native language too, and it can be an important point. We had long discussions with the Chief regarding translation of due process of law. Okay? Due process of law, kaparaanan ng batas. Oops, that's only procedural. Okay? Due process of law, etc. Sabi ko, the better way to do that is to put in Filipino. Siya ay lumaba sa due process of law. Okay? Why? Because we do incorporate into our language things like K, yung okay. For the life of me, I cannot understand why it's so difficult to text O and K. Bakit K lang? Eh, pareho lang piso yun, di ba? Unless, of course, in case, by some sense to me. But on the other hand, we accommodate those kinds of things. So there is very little criticism on that. That is the only check on the court. The more important check on the court is the ability of people that can read decisions to feed to the channels, the media channels, social media, etc., reading those particular decisions. Well, to be fair, I have seen some Twitter accounts that actually read some cases and then point out several mistakes. I have the embarrassing mistake of in the RH separate opinion, it passed through all our proofreading layers. There was a constitutional commissioner whose name was Felicidad Aquino. And I put there, initially in the draft, Commissioner Aquino. And somebody put, proofreader, in our staff, put there, Commissioner Corazon Aquino. And then somebody from the Hague, who downloaded all the decisions in the RH that night when we uploaded it, sent me an email. He said, ganda ng sinulat mo, very convincing, except at one point, on page 30 plus. Ginawa mong commissioner si Corazon Aquino. Sabi ko talaga, titignan ko nga, oh my God, it was really a mistake, and it was in the final format, so we did the procedure to correct the published decision, which was to publish a revised speech. So sa RH, meron ako revised speech, and I do not mind admitting that that was a mistake. Sana wala ng UP Law 37 that you called me out on that. Okay? But in any case, so therefore, that kind of study of cases is still necessary in order to criticize the justices. Okay. There are once in a while some columns that come out, but some columns look at the persons rather than the substance of the issue. Okay. In any case, so therefore, I think that is very important. Next, procedure is important, and you have to be familiar with it. But I will just skip so that I get your questions. The last thing is maintenance of the system. The importance of maintaining the system. Justices are supposed to be beholden only to a particular concept, and that concept is the rule of law. And the rule of law is not the rule of Marvic's law. It is not the rule of justice so-and-so's law. It means a fair reading of the law insofar as how society might read it at the present, considering the precedents, rather than your own reading of that. There is a case called Ocampo versus DNR. Department of National Defense. When I was in college, that was the time when I joined the movement, the student movement. I ran for LSG president under the Straw Alliance. The Straw Alliance carried the color red, and of course we were one of the first that went to EDSA. We called out torture during the time of martial law. I represented clients who were disappeared. I also represented clients who were, as we called them before, political detainees. People that only spoke out the truth against the powers and were incarcerated because of that. On the grounds of their subversion, I had students who were clients who were caught carrying Mao Zedong's materials, the Red Book, etc., the trunk of their car. They were stopped in a checkpoint and their trunk was opened, and inside of which were several issues of Ang Bayan, the publication of the Communist Party of the Philippines, etc. My defense was, Ang Bayan and Mao Zedong's books are in the library of the University of the Philippines. Therefore, it could not be subversive. Back then, when you had PD number 33, of course, somebody made sure that the materials were in the library of the UP Diliman. The UP Diliman library will take any document and put it in their library, in any case. And for good measure, I had a Dominican priest testify in favor of my clients who were students. He testified that they have not sinned, that they are morally upright, and that in Populorum Progressivo, which is a papal encyclical, it is a duty of Catholics to rebel against tyrants. I had him read it. Of course, I did not read the entire Populorum Progressivo, only that portion, which I asked the Dominican priest to read. Bakit Dominican? Because the judge graduated from the UST. So, Dominican. Kung atemista siya, Jesuit. Kung UP siya, do not resent in Greece. The point then is that for moral character, that's marshalling your evidence in order to protect your client. Okay. In any case, so that is those are some of the realities. You have to maintain the system, which means that you have to protect those that do the rule of law. Okay. You know, the judiciary is the weakest branch of government. So weak that it is not designed to do lobbying for its own budget. So weak that it cannot respond to media whenever it is attacked. So weak that its decisions are so thick and it is not put in the way that journalists want it. Dapat may lead sentence ka, si X namatay. Okay? Ours, you have to read the entire case before you get to the follow. By the way, there's a shortcut. You read the follow first so that you understand the case. In any case, better you read the dissents first before you read the main opinion, so that you are more enlightened about the main opinion and you remember it. Well, that's only a trick that I share with you. Now, if the dissenting opinion is 100 pages, forget it, unahin nyo na yung main opinion, wala na kayo oras. But in any case, the point there is that you have to protect that kind of a system, the rule of law. The rule of law sometimes results in something that is uncomfortable. And it is always uncomfortable because there is always a party that will lose out of law. That's the difficulty of being a judge or a justice. At some point, you have to either dismiss the petition or vote for it or grant the petition. And at some point, you are, of course, going to make the choice. Will you make this as a decision that is popular and will please people that you know? Okay? Or will you make this decision that will be surprising to others? Simply because if you follow the logic, that petitioner is right, and even though your advocacy is contrary to it, then therefore it might be difficult for you. Ocampo versus Department of National Defense. There is what is called the political crime doctrine, which means that when you are committing rebellion, all common crimes are integrated in that charge. So no more separate informations for murder, etc., arson, etc. However, in that case of Ocampo, for the first time, the Supreme Court said that there is a limit to the political crime doctrine, which is to integrate all the crimes. This is when the rebel group has committed atrocities, torture, or anything else violative of human rights. In which case, the torture, the murder of civilians is not automatically integrated. It was a difficult decision for me because it was a ruling against people that I worked with in my youth. And therefore, of course, I got criticisms from others. Nag-iba ka na talaga. Or perhaps, Nara Nickel versus Red One mining. People know me as anti-mining. But in this particular case, I said that the petitioner was not a foreign corporation and should be allowed a mining claim. Siyempre, masakit din yan sa akin. Iniisip ko the community that is affected, but that was not an issue in the case. I have to rule on the basis of the pleadings and the issues that were forwarded. And of course, somebody from a large law firm, a former colleague in the faculty, sent me a text. We were so surprised that you ruled in favor of mining. Are you well? Are you all right? And I said, yes, I am all right, and I think that is what my mask and my title and my current office calls me. Okay, in any case, when people do that, they do not have that protection, okay, physical protection of justices. Supreme Court justices, we have closed in. We have security personnel. And no, it's not Steph or Kel. It's a big man, probably outside, checking out all your shares and making sure that none of you are assassins. Of course, I'm not sure of that either. But in any case, but for regional trial court judges, you know, our budget is so low that we cannot provide them with security guards, even for their own sala. Our security guards can only be for the entire hall of justice. So, what is the security protocol for them? We teach them how to fire a gun. Okay, it's part of their judicial orientation, and we allow them to borrow money in order to purchase their own gun. Okay, and we use the JDF for that. Wala namang media dito, no? So, tinik-click mo na yan. Okay, saka na tinik-click. And the reason for this is because judges get killed. RTC judges, more than Supreme Court justices. But Supreme Court justices, 15 lang kami, kaya madali. But RTC judges are in the thousands. Okay. An RTC judge in a province in Visayas had to leave the country because she, during her first few months, came out with a decision against a local politician. Nakatatlong bahay na siya. Okay, palipat-lipat, nagre-rent na lang siya. And every house that she transfers to is raided when she is not there. That's why she is now in Indonesia, in hiding. And we are trying to get her back in order to be able to continue her duties. This is just in the Visayas. And I am not talking about ARMM. There is a judge in the Kupan that had to go to us to tell us that there is this aggressive lawyer stating, using our name, especially mine, saying, alam na to ni Justice Leonen, mag-issue ka ng writ of garnishment. Okay na to kay Justice Leonen. So that judge came to me and asked me, okay na nga ba talaga sa'yo? Sabi ko, malay ko, I don't do that. And can I ask you to file a disbarment case against me? It's now filed with the Supreme Court. No protection because our budget is so low. Do you know that in 2014, the percentage of the budget that is given to the judiciary is 0.85%. Let's put that in more clearer terms. Out of 100 pesos spent by government, the judiciary only gets 85 centavos, not even a peso. Okay? DNR has a greater budget. UP has a greater budget. Of course, dapat itaas ang budget ng UP, and I am all for that. But to give the judiciary only 0.85%, there is no budget sufficient to construct a hall of justice. Again, I repeat that. There is no appropriation item in this budget of 2014 sufficient to construct a hall of justice. All that was given to us is 1 million pesos. Can you construct anything with 1 million pesos? Kailangan mo yata 2.8 billion for a building. No, but in any case, certainly not only 1 million pesos. And the reason for this is because the executive and the legislature thinks that if they transfer it to us, therefore, our budget will be maintained. Okay? But again, the point is 0.85%. Our budget cannot go down than last year's appropriation, so they say, wag muna namin kayo bibigyan ng big ticket items for time immemorial. Okay? So, how does the court construct buildings? The budget for courts is with the Department of Justice. And the only way that we can give our priorities to them is to tell them in a committee meeting, which is called JUSIC, please construct a hall of justice in Tacloban. Okay? And the DOJ uses its own money to construct that hall of justice in Tacloban. Does something happen to judicial independence there? You're a better judge than us on that point. But then again, 0.85. In this year's National Expenditure Program, for next year, the budget that was submitted by the President, now undergoing hearings, the share of the judiciary, because it's now 2-point-something trillion as a whole, it increased by several percentage points. The share of the judiciary is now down to 65%. Sorry, 0.65%. Importante yung decimal point. Okay, so instead of 85 centavos per 100 pesos spent by government, 65 centavos. Okay, per expenditure of government. Okay. They tell us, meron naman kayong JDF, Judicial Development Fund. This is what we collect from docket fees. But that's only 1 billion pesos. And 80% of that is shared with all our personnel. And each personnel gets from 1,500 to 2,500 in addition to their income. 2,500 for our personnel. That means judges and staff. Okay, pag tanggalin mo yung JDF, tatanggalan mo sila ng 2,500. Who are you making suffer? Is it the Supreme Court that ruled against you in a particular case? Or is it simply judges that add 2,500? Judges' salary are so low that they will avail of benefits given to them by the local government unit. And it's no secret. Trial court judges get benefits honoraria from local government. Okay. Now, I ask you, where is the venue for cases filed against a local government? It is always in the regional trial court in a local government unit. And for the life of me, people cannot see that just because the salaries of trial court judges, huwag natin isipin yung Supreme Court judges, trial court judges are so low, they have to resort to this. Takot na nga sila, utang sila para sa baril. By the way, we also have a motorcycle program for some judges that do not have a car. Okay, hanggang 50,000 you can loan, and you have to pay it by withholding part of your salary. Okay, motorcycle. Okay, and therefore motorcycles they're already in debt, and then you ask them to depend upon local governments for additional allowances. Why? Because the budget is low. So why don't you lobby for larger budget? How can we lobby? We are not designed as a political department. We are only there to make a presentation during the budget hearing, and then do you expect us to go to each and every congressman and each and every senator paki-increase na yung budget? And some congressmen have cases in the court. Some senators have cases in the court. Some of them have filed the case against their opponents or filed the case against a project. Some cases are filed against them, sometimes criminal, sometimes in the civil matter. So, the better part of wisdom is that justices, when they go at all to the budget, they do not mingle around. Because that is supposed to be our training. We cannot sit with you if you have a pending case, unless both lawyers are present. And in a budget hearing, that is difficult. Okay? So, who lobbies for us? That's a good question. Who lobbies for the judiciary to maintain the entire mechanism? And I tell you, nobody. Nobody. In the past, it was upon the largesse of Congress and the executive when they add certain portions in the budget. Last year, we asked for one legal researcher in addition to the existing one, kasi one lang. So we add one more. So magiging dalawa per trial court. The legal researcher we were asking should be coterminous para confidentiality is there so that the judge can choose who they trust to do the research for them. Tig-isa per trial court. That was about 4 billion pesos. Okay. Reasonable, 4 billion of a trillion peso budget in order to add one more legal researcher per trial court. It was denied by Congress. Hindi in-include. Okay, of course. Vehicle acquisition program in order that judges and justices become mobile has been reduced to only 1 million. 1 million. You're kidding me. You cannot buy, well, you can buy the vehicle of the UP College of Law for 1 million. So pwede yun. Yung crosswind, nandiyan pa ba yung crosswind, yung mga Toyota natin, and so on and so forth. Okay, but in any case, again, there is that particular difficulty. Judges and justices have to look for their own resources to be able to live somewhere, whether to rent someplace or to purchase property, which is very, very also difficult. In any case, you have that in the minds of judges and justices that rule on particular cases. It is difficult as it is that you are ruling on a political case, but more difficult when you realize that when you rule in a particular way, you will bear the brunt of the political departments. Okay. However, at certain stages, the court has said, if we do not do what is right, who else will do what is wrong? Okay? Courts in the past made mistakes. That's true. It is not a perfect institution. And of course, there were some instances where, because you really wanted to build a building, that certain shortcuts were made, not of this court, but perhaps some other court in the past. But the point there is, if we are afraid that people call us out with respect to our mistakes in the past, then we will never be able to do the right thing in our decisions. I do not think that is seen by the public. Nagdadrama lang yung threats for impeachment. By the way, with the threat of impeachment, I can share with you, justices have said, when that came out, when people were saying, let's impeach them. Some are, of course, we are not strangers to litigation. And we know that in impeachment, you will have your opportunity to be heard. And therefore, it is not by the mere fact that you invoke it that we will be shaking in our boots. What really scares us is a law student somewhere writing a law journal article or a paper for a course and then uploading it in Facebook or in Longer, kung kaya nyo, okay? Saying, Justice Leonen forgot that there is Article 2176 of the Civil Code. That's scary. Why? Because we only will stand on the basis of our legitimacy in terms of our reasoning process. Or the other thing that scares me is, sabi mo, 77 skra, 77. But it is actually 77 skra, 85. Yung 77 is another case. For a law student who will say, what you cited is not ratio decidendi of the case. Okay, that scares me. Okay, and keeps me with sleepless nights. Okay, whether this is correct or wrong. So therefore, I rely on my lawyers. If there is a mistake, it's the fault of my lawyers. No, just kidding. It stops with me. I check it, I read it, I examine the primary materials, I write the decision, make sure that it is cogent, and so on and so forth. Okay, but in any case, you need to assist, maintain that particular system. Let me summarize. You are not going to do this for yourself. You are going to do it for some other person. You will become powerful only because you are competent. You have integrity, independence, and you are analytic, or you have that mind of problem. You will be powerful because of that. But your power does not depend only on you. It depends upon a system that works on the principle of the rule of law. And we end by saying, we once were councils of certain indigenous peoples who were up against the largest mining company with the largest concession in the Republic of the Philippines. This is in Well-Vista. Okay. And when I left lawyers with that NGO. And a lawyer, smaller than I, thinner than I, of course everybody is thinner than I, okay, filed a suit in a regional trial court asking for injunctive relief because the mining company was about to take in their base camp and the people there did not actually want mining. She found the reason. She got a writ of injunction against this mining company. Okay? Very small individual. What was her skill? Knowing the law, knowing the facts, and knowing how to argue it. So she wrote a pleading. She requested by motion an issuance of a writ of injunction. She got it. And for a while, the entire community was shielded, not by an army of men and warriors, but only by one lawyer knowing what she should do at any given circumstance. That's your power. And that power will be done if the rule of law is not what prevails over the court. You may not like our decisions. I do not like some of the decisions of the majority. That's why I dissent. They do not like when I get a majority too sometimes. Okay? But the point then is, that's how it goes. There are people you put there that is supposed to be not subservient to the political result or the civil result or the commercial result, but to the result only that upholds the rule of law. Constitutional democracy is strange. It requires maintenance from the sovereign, because the sovereign has to be guarded against the excesses, including corruption, of all the departments, including the judiciary. By the way, just to get this over with, our salients are out there. Our salients are out there. Okay? You get it from Rappler, you get it from DT5, from JLE7. They have copies of our salients. And therefore, it is not true that we are hiding our salients. Okay? I am not hiding my net worth. In fact, my net worth, I think, is overstated a little. Because the requirement is that you state the acquisition cost, not the depreciated cost. But in any case, the point then is, it is out there. The sovereign needs to maintain a constitutional democracy. But the sovereign, which should not only do monitoring, it should advocate for what it feels should be right. Okay? The Supreme Court and the judiciary have their weaknesses. We have committed mistakes in the past, and that is true. Whether in precedents or maybe in some administrative manner. I am not sure about the last one. But the point is, I know that it's a human institution. But for so long as it works for the ideal, it is worth your support. Again, we are looking for champions because we should be able to do what it is that we do best. Rule with integrity, rule with the law, rule of law. And for so long as the legal profession does not mind us, in other words, does not support us, for so long as the public does not support the judiciary, then you are allowing us to really be the weakest branch of government. Again, thank you, and I hope that you will finish your 4 years here. After you finish your 4 years here, pwede hanggang 6 yata. Kung ano, gusto nyo. Transfer to the evening class, pwede kayo siguro hanggang 7 or 8, if I'm not mistaken. Subject to MRR, kung talagang desperado kayo, meron pang Board of Unions paper. Okay, na pwede. And then, after you take the bar, come out as a lawyer, remember these words. Serve the people. Thank you very much.
Thank you, Justice Leonen. We will now open the floor for questions. Please note that we have a mic in the middle of the room if you'd like to ask a question there. We also passed around pieces of paper. I'm not sure if they've been collected already. They will be collected in case you're shy. And so far, are there any questions? Yes. Okay.
Morning. Good morning, Justice Leonen. I'm a freshman from Block B. We talked about the Bangsamoro Agreement in class, and given your role in it, what are the chances of it being enacted? I mean, being executed, and by when would it be executed? Thank you.
Then, media person here. Cannot answer your question because I do not know. The only thing I know is that the whole framework agreement, has what we call a roadmap. Okay? And that roadmap, I think, is still followed to the letter, which is that there should be a law that avails of Article 11, Sections 15 to 22 of the Constitution, which creates an autonomous region in patterned after a common identity, which has been identified as Bangsamoro. Bangsamoro is not a citizenship, it is an identity. It is the same as law student identity. When you go to Starbucks, you bring your law book, okay, and you distinguish yourself with a particular identity, struggling law student. Same thing. Okay? When you go to church and you choose the Catholic Church and pray to Jesus Christ, then you become a Catholic. That's also an identity. The same as Bangsamoro, not a citizenship. Your citizenship is also an identity. Okay, so it is undergoing that process. Let me tell you something about negotiations. Negotiation has its ebbs and flows, ups and downs. Media plays it as if it is really going well, then it should always go up. The truth is different. The truth is there will always be successes, small victories, and then going down. Okay? And the victories can be incremental. It's incremental first until that eureka moment happens, when suddenly everything comes together. I still remember that time, when everything came together, and then finally we put in the last word in the framework agreement. And the last word was on. On. We fought that. Off or for Bangsamoro. Okay? Off for. On pala. Oh, on. Therefore, we completed the agreement. Everything came together at that particular time. I can only say that the Bangsamoro law can only come to fruition if there is support from the people. And the Moro Islamic Liberation Front agreed that they put their faith in the broadness of mind of the entire Filipino people. Why? They accepted that it goes through Congress, and then the Senate, and then to a plebiscite in accordance with the Constitution. Okay? So, yes, there are snaps. And every snap, masarap na gawing istorya sa media. Okay? It's like you're together with somebody. Siyempre, it's all ups and downs. Kung puro up, there's something strange with your partner. Kung puro down, you should emphasize the moments when you are sad in your relationship. It doesn't capture the entire thing. Okay? They should capture love. Okay? And so on and so forth. Same thing with the bangsa. So that's the only way that I can respond. And to be frank with you, after I joined the court, I did not know of any other meeting in terms of the negotiation. Prior to that, of course, as a negotiator of which you will become, you should know yourself, you should know your enemy, you should know your subject matter, you should have a prognosis of how it's going, you should have back channels. I lost all of that when I took my own.
Thank you for that question. Are there any other questions? Even those written on the slips of paper.
Graded, it's okay. I missed the times when I was the one asking the question. And if you were unable to answer, I would send you out. But I was the kindest professor in this college.
Any other questions? So there are none. Actually, we have a few questions in the slips paper. No questions. So if there are none, I guess we'll take this opportunity to thank Justice Leonen. But first, we will have a few words from one of our partners from the International Youth Council, Philippines, Sir Alvin Danos.
Thank you. I feel like a law student now. I'm a nurse by profession, by the way. We're the International Youth Council. We're the partner of the Law Student Government. Kay is also one of our officers. She is our Deputy Director for, Assistant Director for Legal Affairs. Legal Affairs na siya, again, siya lawyer. But then again, we're happy that you're here. Thank you, Justice Leonen. I was there also out the RH law. I was there in Baguio as well when we made the historical decision. And we know kung anong pinagdaanan ng hirap ng isang batas. Paano siya maging batas, paano siya maging isang batas, paano siya dinidepensahan ng mga taong naniniwala sa batas. Isa sa nag-strike sa akin today was when Justice said that who will lobby for us, who will talk for us. Oo nga, no, I asked myself that question then. Kasi we've been battling with a lot of issues, we've been advocating for a lot of issues, health issues, issues of women, issues of young people. But yeah, not the issue of the judiciary. You know, you don't even know what's happening in our courts. You don't even know what's happening in the halls of justice. You don't even know that walang appropriate budget or walang sapat na budget for our justice. At oo nga naman, we always ask ourselves, paano nga naman sila nabubuhay? Lalo na sa safety nila, lalo na kapag sila ay nakaharap sa mga issues like what Justice said. And I ask myself as a lobbyist and as an advocate of several issues, I have not even touched that part yet. But the question is, now that I know about these things, will I touch on the issue? Will I advocate myself? That's also a question for you guys. Now that you know the issue, will you advocate on that issue? Or will you continue just sitting around, becoming a struggling law student? So where do we draw the line? And where will our actions take us? So now that I know about it, parang sabi ko, I'm interested to know more about the issue so I can advocate more. Kasi mahirap magsalita on the issue that I do not even know about. So as a youth advocate, and now that you are also would be a youth advocate, I pass that challenge to you. Take that challenge and then speak for them. I mean, they can't speak for themselves on that matter yet. But be that voice for them. I mean, we can start that movement. We can start that. I mean, hindi ako law student at hindi din ako lawyer. Wala akong masyadong idea sa law. But I know one thing. They are also human beings needing to be heard and needing to be taken care of. At sino mag-aalaga ng putik tayo? Tayo lang din. So that's a challenge I pose to all of you now before we end this session. And we invite you again next week. We're going to talk about something that's very about public accountability and something that's more controversial. But then again, tingnan natin at imayin natin yung mga issues na hindi lamang yung personalidad, hindi lamang yung mga controversial parts of it. At sana makita namin kayo next week. Dito pa rin ulit no, sa Mountain Hall. Yeah, sa baba. Okay. We're also inviting some other young professionals, young leaders from different schools, different organizations to join us. And do invite your friends as well. So, sana makapunta din sa Justice if ever. Kung free ka pa naman. But then again, I thank you guys for coming, and I hope that you will join us in our cause. You can visit the International Youth Council in our website, internationalyouthcouncil.org, and join us in our advocacy for other issues. And if you have any questions, you can just ask Kay, because she's also our officer. But just in case if we're not here, thank you very much, and have a great day, everyone.
So we'll open the floor one last time for questions. I believe the papers have been passed around, just in case anyone feels like asking anything to our keynote speaker, Justice Leonen. Yes, go ahead.
Good morning, Mr. Justice Leonen. I'll ask na rin kasi it's not every day that you see a justice and you get the chance to ask. By the way, I'm Red Minus from Block A 2018. So, I'll ask lang po about dun sa budget ng judiciary. It's unfortunate kasi na nag-start na yung deliberations ng Congress, so we cannot do much about the current proposed budget of any department for that matter. Pero, halimbawa lang, hypothetically, we successfully lobby for a higher budget, which would enable the judiciary to magpagawa ng courts, halls of justice. Paano po i-manage yun? Does the judiciary have a complete plan kung paano i-implement yung mga improvements?
The judiciary is not only composed of justice and judges. It is comprised also of a lot of administrative staff. And we do have an infrastructure that has the capability of actually doing the business. We have an annual procurement plan. The Supreme Court is not a stranger to putting up buildings in the past. And we have what I can ask is that if you allow the proposed judiciary's budget, the proposed budget of the 8 billion, along with what is actually the national expenditure plan, we uploaded our internet so that people can see the difference of what it is that we have asked. Okay. Just one trivial fact. The budget, every budget item is divided into 3 different cost classifications. You have personnel service, you have maintenance and operation expense. I'm sure some of you don't take public finance, and you have capital outlay. Personal services, well, that's for the salaries and benefits. Capital outlay, that is for buildings, etc. That one we do not have. Maintenance and operating expenses, let me share with you this fact. When we computed per capita, okay, what per month a trial court gets per capita, equally divided, what per month they get on the existing budget, you will come to a figure like 110,000 pesos per month. Can you imagine that? 110,000 for your light, electricity, paper, everything. Okay. An equivalent unit outside, an equivalent number of staff in the executive, with an equivalent number of staff, their MOE is up to 1-point-something million per month. Okay? Trial courts on the average has 14 staff. Okay, that executive department staff, that office has also 14. Okay, now, if you divide the entire budget of the judiciary, divided by all our personnel, so per capita, okay, kung ano ginagawa natin para mapakita lang na kawawang judiciary ninyo, no? So we divided it. You will come out to a figure like 400,000 per person. Of course, lahat na yan. Okay? You know, House, 1.8 million. Senate, something like 1 point something million. Figure escapes me right now. Okay. And the question is, this is a department that is equal to all the rest. Okay. In terms of how we actually spend, you know, GOCCs are given more flexibility in the budget than the divisions. Government-owned and controlled corporations. Some are even big core, okay? I think NHA are exempted from salary standardization. UP can be exempt from salary standardization. Their professors can have additional income if it is from the income of the university, which is of course not too much. That's why your professors are also somebody or a group that you should also advocate for. I've been there. Okay, and I can share with you the actual numbers. And your professors here, especially the full-time faculty, are really doing a lot of service for so little, even the government. But the point then is that it is important that you understand that this is also a situation that there. So yes, we are going to salary standardization. We are controlled in terms of the salaries. Okay. The President of the Philippines gets 150,000 pesos per month. How do you know? You just look at the salary standardization law and look at the latest table, which is the fourth table. Okay, the Chief Justice gets almost as much. Associate Justice gets 90,000. Okay, 90,000. In-house counsel of a very large transnational corporation in this country per month gets 2 million. Okay, and by the way, on our docket we have issues that involve hundreds of millions and even something like a case which actually will mean payment of 62 billion pesos. And to give your justices 90, in a body justices, we have other benefits. But you look at a trial court judge, okay, it may not be far from that. Actually, it's about 70 plus thousand pesos. Okay? And you are thinking, these are people who you prohibit from actually talking to anybody, from doing any other business, from doing any other profession, and sometimes even prohibited from teaching until their docket becomes more reasonable, yet you give them that kind of an amount. Okay. I don't know if you have families, but let's talk about the regional trial court judge. Okay. If you have a spouse that earns, and that is one thing, look for a classmate that is rich and marry that classmate. So that you can do public service. Tumingin na kayo habang nasa first year pa lang kayo. Okay, by the way, you're not limited to the first year. You can look at the fourth year. Huwag lang sa faculty. I think they feel that Freud is well pa yun of any consensual sexual relations in the faculty member. When I was I issued a memo prohibiting that. And a faculty member told me, good luck. Leonen, you cannot stop love. You can if you want to focus on your studies, but that's the point. If they are married, then they can rely on the spouse. Okay? If they are not married, and many of the trial court judges are not, for one reason or the other, your generation marries you. And normally, you will have children on the average. You are a woman at about 30 plus already, demographic side. If you are a man, it is possible that you will not get married because nobody likes you. But the point then is, then they will have to rely on that. You have children. And a school year, a good school year, and you want to put them in a good school, the tuition will range from 100,000 to about 500,000. Of course, if you put them in a public school like UP, it's still 36,000, I think, their tuition for one semester, excluding all the photocopies. Pero dinayata ko sila, USBs that you purchase. And then you go to Scribd, and then you download the magic notes of your professor. I've seen one, it says, at this point, the professor will crack his joke. Then some of your professors told me they were asking copies from the students. And the student will say to the professor, I will have to ask permission from the person that wrote it. Okay? So in any case, go out and professor. But the point is that you have children, okay, you have to provide for their health. People that enter the judiciary are normally not only wise, but old. And as you grow old, you will have a good health program. Okay, I cannot tell you the kinds of conversations we have when we have lunch together. Okay, tinanong ako, nag-stem cell ka na ba? Kasi normal to. Diabetes, you have diabetes. And a lot of the people in court have diabetes. Due to any stress-related disease, name it, many of the justices of various levels of courts may have it already. And these are not cheap. Okay. You want to protect them, you want to insulate them, you want to be able to tell them, you sit down, we'll take care of you. But you give us the right decision. Do not fear for whatever it is that you need to provide, your family, etc. True. You have survivor benefit program. This is a career goal for you not to join the judiciary. When we die, okay, our retirement benefits go to a spouse. Okay, that's why it is dangerous to have a spouse when you are a justice or a judge, because you might get killed so that the spouse gets your retirement. The point there is that they give you that kind of security. But that happens when you're over 70 years old. What about while we are there? What is our assurance that we can take care of our family? Then taxes. We are paying 32% of our salary in taxes. That's in the tax code, 32%. And we now pay the right amount of tax, notwithstanding what the Commissioner of Internal Revenue is saying. Per our judgment, we are paying the right amount of tax. And we are the Supreme Court of the Republic of the Philippines. But in any case, if they want to review it, then fine, review the amount of tax that we pay. So of the amount we give to a trial court judge, 1/3 of it goes to tax. Can you imagine what is left? Okay, so you are with a client, there is a bit of garnishment being requested for 1 million pesos. Okay, and of course, the temptation will always be there. Judges are human. But you have to have very, 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 very strong character in order to resist them. Of course, there is no excuse for you to be corrupt, and certainly we have dismissed a lot of judges. One, for sure, last Tuesday, we dismissed a judge in Leonen. His offense was that he met with a party. He met with the party to tell the party that he is siding with the other party. Okay, so dalawang offense niya. Plus, he asked his clerk of court, or stenographer, to arrange the meeting for him. Pangatlo. Pang-apat, they kept in constant touch by text messaging. Okay, so that means, apat, dismiss. Okay, there is no excuse for that. There is no excuse for you to receive money from the litigant. There is no excuse for you from taking from the pie that is given to the winning party. However, the temptation is so great that it can be very, very stressful. Okay. Things like gifts given to judges. Okay, like, sige, libre na kayo dito sa hotel na ito, pwede kayo kumain o kayo magbayad. Okay, of course, I do not accept that. Okay, but if you were a judge, kulang kayo sa phone. Okay, and in one restaurant in your province, the restaurant owner says, wala naman po akong kaso. Pwede na ako kayo dito. Ito malaking discount ka. 90% discount. So, talo niyo pang senior citizen. But at a certain point, that person will have a case with you and you will be convicted. So, you will either have to leave it or you will have to do the case at a great disadvantage. Okay, so, what the person from the International Youth Council said is very true. You know, your judges are very human. Okay, and it pains us to dismiss judges and justices. It really pains us. It's really a very difficult thing. By the way, stenographers, the same thing. Process servers, the same thing. People that write the transcript of stenographic notes. Okay? There's supposed to be a tariff for it. You pay a certain amount. But sometimes they ask for something else. When I was a practicing lawyer, I remember in one particular court, the strangest request. Sabi niya, attorney, hindi ko magawa yung transcript ninyo. Kulang po yung vitamin sa anak ko. Okay? So I brought vitamin the following day for the child. Hindi po yan yung ibig kong sabihin. When I looked at it, it was multivitamins. Ayaw niya. Okay? Which meant something else. They needed something to buy the preventive vitamins. So, meron yun. Okay? Or, they go to a courtroom, there is a stenographer there that has to speak it, canvassing for Miss Barangay. I don't know if you're familiar with that. The more you sell, the more that their children will become the Miss Barangay or something else. Okay? So, sabi niya, can you buy a ticket from me? And of course, as a stenographer, I'm a dubigan before. So what I did was buy one ticket. And people, yung booklet, pwede niyo mag-relate to booklet. Okay? And you will face with a moral dilemma in that particular instance. One way to protect is to discipline the judges. But the other way is you should provide to your judges and justices what is necessary in order that they are not getting. We're not asking for too much. We're not asking for millions of pesos per month. I think for judges, trial court judges, it's just a living wage. And of course, again, nobody explains this. They assume that every government official receives this kind of a salary, therefore you should be the same. Yes, but every government official, some of them, are allowed to do business. On the other hand, judges and justices, you're supposed to be immune. You're supposed to be hermeneutically sealed from society so that you're able to actually see the issues for what they are. Okay, so that's my pitch for the income of judges. But the other thing is, of course, we need very competent individuals to get into the judiciary. Okay? And I am so happy that your court now, there are many alumni that have decided to join the judiciary. Do you know that your Supreme Court, in your Supreme Court right now, of the 15, 7 are from this country. Okay? And of the 7, do you know that 4 of them used to be faculty of this country? Do you know that the top 4, chief, senior, number 3, and number 4, are all from the University of the Philippines? All the chairs of all the divisions in the court are from the University of the Philippines. Okay? That's why it's controversial. We have very strong opinions. When you come from this college, when you get out, you have very strong opinions about the law and how you interpret the law. But yes, that. Also, that the acting Solicitor General, and I think you will have a science with it, used to be a constitutional law professor. I don't know if it is. But also from the faculty, also from UP Law, very young, graduated in 1999, topped the 1998, topped the bar in 1999, and is an atheist. Sinagdag ko rin yung pangatlo. You want to know. But during his classes here, he has written, while he was here, he has been published on a lot of material. Your acting Solicitor General. The Public Information Officer of the court is also from the University of the Philippines. A lot of executive judges in this country are from the University of the Philippines. It's a career. And I think we take to heart, rather than join a bank, become in-house counsel. And of course, you know the compensation in in-house counsel. I think the in-house counsel of Avon Province earns twice or thrice all the benefits of the Supreme Court justice. Avon products, hindi pa kayo make-up. Good. So therefore, it is important that you understand that there is this necessity also for competency.
Morning, sir. First, I would like to say that it's very refreshing to hear from you once again. And secondly, you have without hesitation, I'm here. I would like to ask Your Honor if, after having said and considering the situation that the judiciary is in, as regards the fiscal compensation, what would be, in your opinion, the main driving force for anybody to join the judiciary? What would you suggest to them that they consider why they would pursue this, considering the situation that you have illustrated for us?
You can write a very long decision and have it assigned to your student this afternoon. but you are able to do what you think is right and make a difference. Okay. Whenever you save a person who is wrongly accused and based on reasonable doubt, then I think it is all worth it. A single person, no matter from where. During the last division meeting, there was a 62 square meter property somewhere in Tondo, 62 square meters. And they were fighting over the rights to that 62 square meters. And these are urban poor individuals. Very rare you get that kind of property case in the Supreme Court. Why? It's expensive. You have to go to the MPC, RTC, Court of Appeals, Supreme Court. When I look at counsels, I said, siguro itong dalawang ito, robot. But it was about 62 square meters. So we were able to resolve how it should be legally and legitimately allocated among two families that were fighting over it. That civil issue in itself is worth it. Okay? Standing up and being able to say that when Congress actually prescribes a whole menu of options that is safe and non-abortifacient, in order to be able to save a mother somewhere, okay, or a family somewhere from the deprivations because they have too large a family, to be able to say that that is not unconstitutional. Okay, I think the people who were in Baguio were remember this. Telite comes out, Professor Telite, and then announces. So in Corpus both states that the RH law is not unconstitutional. Tahimik yung crowd because they're figuring out not unconstitutional. So there was a bit of silence until the pro-RH I think shouted, "Panalo tayo! Yay!" Then Teddy says, "Except for the following provisions," tumahimik yung pro-RH. And then ABCD, then it was the turn of the opposition. Okay. Those moments are worth it, at least for those that join the judiciary. And it's a career that I think where you can use your intellectual ability, your skill in persuasion, your negotiating skill to be able to do a difference. When you're in the judiciary, either as a trial court judge, court of appeals justice, etc., you're beholden to no one, except the possibility of a certiorari to a higher court or an appeal to a higher court. And you are only beholden to your reading of the law and your conscience. Cannot imagine. Incest happens. To be able to convict a person for life imprisonment because he raped his daughter of 6-year-old several times. Okay, I think is good. Can you imagine what a 6-year-old has gone through and the kind of psychological imbalances that she is now suffering from? So I think that is worth it. Not everything in this world is about material wealth. You need material basis for your existence. In other words, you have to buy your clothes. Okay? It matters also when you have good business attire to present. Hindi naman kailangan design. Okay? Because if it's Louis Vuitton course, you don't always show Louis Vuitton to. Now listen to my argument. It can be a simple one. Okay? You need material basis. You need to be able to provide for your children. You need to be able to give them education. But I think what is worth it is that you're doing something that you like. I think you will hear it from a lot of your professors. Do not do work. Do not do work. Do your passion. Because when you do your passion, you're not doing work. Okay? And that passion should be something that will help the people. Because you're entering a profession again that is not for you, but for somebody else. The most popular lawyer, strongest advocate, Pape Tejo, again, Rene Sangisan, before, okay, etc. Even Jejo Martin